Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. When a plaintiff files an employment discrimination lawsuit, the defendant will almost always ask the plaintiff to consent to a protective order. A protective order to prevent what the defendant purports to be confidential information from disclosure. And that's what we are going to talk about today. We are going to also talk about what is confidential information, what is not confidential information, or what may or may not be confidential information. And we'll also talk about the plaintiff's right to object. So let's get started. A nutshell. A protective order is intended to protect confidential information from discovery or public disclosure. And I'm going to be focusing on confidential information in the context of employment litigation and discovery. Although non-employment litigation cases, the parties seek to file confidential orders. So before we get into the nitty-gritty of the confidential order, there's some things I want you to know. You need to know going into this, okay? Good cause. The party seeking to protect information from discovery or dissemination must show good cause. And in my experience, it is usually the defendant who is attempting to get a confidential order signed, because the defendant will push hard to keep their material from being disclosed, and they will push to designate their material as confidential information, even though it may not be confidential. So hold them accountable to their responsibility to show good cause. And if you have to, politely remind the court of their obligation to show good cause. For a good cause to exist, the party seeking protection bears the burden of showing specific prejudice or harm will result if no protective order is granted. And I provided you with a case that illustrates this, Philip versus General Motors Corp. And the showing must be made for each individual document the party seeks to protect. Again, hold the defendant to that and remind the court if you have to, politely and respectfully. So let's look at what confidential information is not, or may be. Trade secrets. Yes, they are considered confidential information. Trade secrets examples would be methods, processes, business and financial information, computer programs, unpublished patents, and things like that. Courts have broad authority to devise protective orders to preserve the secrecy of trade secrets. And I've given you a case that again illustrates the power of protective orders when it regards trade secrets. Personal private information, yes, typically protected by state and federal privacy laws. Examples of PPI would be a social security number, birth date, credit card information, health information, just for example. Information that is embarrassing or of a harassing nature. I've read cases where it is considered confidential information, and then I have read where it was not deemed confidential information. But if you read this case here that I've cited, you'll see what I mean because it illustrates both sides. Information that is already public or known to the public. Obviously, that is not confidential information. Communications protected under the attorney-client privilege. It is confidential information. That said, now, pro se, because you are your attorney and the client, there is no attorney-client communication to protect. Settlement agreements, yes, they are confidential. Now, but information in the settlement agreement could be disclosed, for example, to an insurance company or shareholders, or where there's subsequent litigation. So, even in these situations, it's still considered confidential because it's released to certain eyes only. You got it? Medical records and psychiatric records are confidential under state law. Now, in litigation where the records are causally related to the issue in the case, the court may and probably would conduct in camera inspection. An in camera inspection is where the judge privately look at confidential information, sensitive information, private information, for example. A lot of times employers will designate manuals and operating procedures proprietary and confidential. And these items may be proprietary, but they are not necessarily confidential. A federal court in Kentucky, for example, rejected Home Depot's argument that its training manuals and standard operating procedures should be protected. You can find that at the case cited below. So there is one takeaway here. Self-advocacy. You've got to advocate for yourself. Inspect the document meticulously. Don't be intimidated by the document. I'm referring to the proposed protective order that the defendant will ask you to sign. Go line by line. And as you go by line, have an idea now whether the item is confidential. If you have to conduct research to find that out, you do that. If you disagree with any part, any item in the proposed protective order, submit your proposed stipulations, what you would consent to, and be prepared to cite law on points of disagreement. Remember, defendant must show good cause. Hold them to it and remind the court if you have to, but respectfully. I trust this information has been helpful to you. and I will see you again. I am Advocate Lucinda. Be empowered. Take care.